Oral argument this morning via Zoom. We're hearing one case this morning, that is Cheyenne Colvin et al. Versus Governor Inslee et al. I went to welcome counsel and thank you for appearing by Zoom. And for the petitioner, we have Mr. Nicholas Straley, who will open for 22 minutes, having reserved 8 minutes for rebuttal. And for the respondent, we have John Sampson. So Mr. Straley, if you would like to proceed. Mr. Straley, you're muted currently. I'll just ask you to start your volume. That'll be, I'm sure we'll have to say that more than once. Please proceed.
I'm terribly sorry about that, Your Honor. May it please the court, my name is Nick Straley, and I'm here in my offices with my colleagues Janet Chung and Nicholas Allen, and we represent the petitioners in this matter. Your Honors, COVID-19 is so dangerous and so contagious that it's actually illegal for us to be in the same room this morning. But nonetheless, my clients sleep in the same room with 2 or 3 or 25 other people. And when they wake up, they're crammed into day rooms, they're crammed into mess halls, they share the same bathrooms, the same sinks, they share the same tablets, the same computers, the same telephones. And Your Honors, overcrowding is always unpleasant. Sometimes it's unconstitutional, but in this case, it can be deadly. And that's why we're here this morning. We're asking for an extraordinary remedy to fit an extraordinary moment. And why are we here? Well, because the state has violated its duties to our clients, and there is a remedy that this court can and should provide to the petitioners. Where does that duty arise? It arises from Article 1, Section 14 of Washington's Constitution, the Cruel Punishment Clause. And what does that duty require the state to do? That duty requires the state to protect our clients, the petitioners, and everyone within Department of Corrections from a substantial risk of serious harm. That's the standard set out in the Farmer case and the Helen case. And what does that mean? Well, in the context of an infectious agent, all of the case law is clear. That in failure to protect from an infectious agent like COVID can constitute cruel punishment. And we've set out the case law at page 45 of our brief that discuss those cases. That's the Helen case.
Counsel, I have a procedural question about the future of the case. If we were to agree with your argument and grant the relief you're requesting, whatever that might be, and whatever that might look like, procedurally, where would we go from there? And let's just, for purposes of this question, assume that the cure is miraculously, and hopefully this is correct, found, and the disease is eradicated. Is the power you're asking us to exercise one of commutation of, or what? Would we then call all of your clients back into prison, or what would the procedural future of this case look like?
Thank you, Your Honor. And I think there are a number of cases that are instructive on this point. So for example, if you look at the Plata case, what the Supreme Court did there is they said that there are many people that need to be released because of the unconstitutional circumstances in the California prisons. But what they said is to the Department of Corrections, you go back and figure out how to meet this requirement. So you come back with a plan to tell us how you are going to get to the requisite number of people to make sure that it is safe. The same thing could hold true here. We actually don't have a position on which tool the state should use to release people. We've given them, there are numerous different types of ways that people can be released. And though the decision about which tool to use may well be within the discretion of the executive to make that determination. So whether it be furlough, Jessica Gonzalez, I see that you're speaking.
Let me ask you about that. Thank you. I neglected to take myself off mute first. Haven't we already said to the state, show us what your plan is? And haven't they done that? And hasn't the governor taken some extraordinary measures already, even if it hasn't all been effected yet, that show that the executive branch does have a plan to meet this within their discretion? And if it's true that we don't tell them precisely how to exercise that discretion, what is it we should do aside from perhaps continuing to monitor their progress in the plan that's now been provided to the court?
Your Honor, I would refer you to the 2 supplemental declarations that we filed from Secretary Pacholke and from Dr. Greifinger. And these 2 people have taken a look at the plan, the limited release plan that the state has issued. And each of these has a basis to know. Dr. Greifinger helped the Department of Corrections set up its medical system. And Secretary Pacholke used to run the Department of Corrections. So these are two people who are intimately familiar with how the department operates. And what they each said is that the release plan that the state has issued is insufficient to meet the current crises. Insufficient.
Counsel, isn't that seems like a difference of opinion? I mean, if they were still working for the department, they would be exercising that judgment on behalf of the state. Now they're exercising judgment as expert witnesses. But isn't that just a disagreement?
Well, Your Honor, there's a disagreement, but the state hasn't presented any evidence to demonstrate their plan will meet constitutional standards. What they haven't done is haven't demonstrated that social distancing is possible in every prison in Washington. And in fact, all of the evidence before the court suggests it's not. The only evidence that's presented to the court about what is actually happening on the ground in prisons comes from the petitioners. There's not a single shred of evidence presented from the respondents that talks about what's happening on the ground. In addition, Your Honor, what I would say is I would refer you to the series of cases that we refer to in our response to their reports, the voluntary cessation cases. And what they say, that line of cases says, is if a defendant begins to take steps to remedy a problem after being sued, the burden shifts to the defendant to prove their steps are sufficient to meet the problem and they won't go back at any time in the future. And I would submit that because we sued them and because Your Honors issued their order, that is what forced them into releasing people. They now have the burden to prove that what they are doing is sufficient to meet the constitutional standard, and I submit they have not done that. In fact, the only evidence is to the contrary.
What is the constitutional?
Justice
What is the constitutional standard here? Is it the deliberate indifference standard? And if so, given the steps that one of your clients, Governor Inslee, has taken, doesn't that negate the deliberate indifference standard? And I'd be interested in your opinion about the steps that your other client, Secretary Sinclair, has taken.
Well, Your Honor, it's our position that what Governor Inslee and Secretary Sinclair have done aren't sufficient. We believe that's the case because they have acknowledged that release is essential. Governor Inslee in his proclamation and in his commutation order acknowledged that release is a necessary step in order to protect people in Washington's prisons. They have now issued a limited release. We believe
the deliberate indifference standard starts by asking if there's an unconstitutional situation, an unconstitutional risk of harm, but then the Eighth Amendment deliberate indifference standard goes on to ask whether the respondents have been purposely or recklessly, in other words, deliberately indifferent to that standard. Is that the standard you're proposing that we use?
Well, the standard, Your Honor, is that there's a substantial risk of serious harm that the defendants appreciate. And everyone here appreciates there's a substantial risk of serious harm. That's not in dispute. The fact that they are releasing people indicates they know that it's dangerous inside the prisons, and they know they need to release people. They haven't taken sufficient steps to ensure that that is actually the case, though, that their plan will actually meet the moment. They have not done that. There's been no analysis, Your Honors, of what it will actually take to allow for social distancing in each of the prisons. The Department of Corrections hasn't provided that analysis. What they have done is they've identified some people to release, and it's important to remember who these people are. Many of them are people they would have released in the next 2 months anyway. And the Department of Corrections is continuing to bring people back into the system. And remember, we are in an 18-month odyssey. This is not a 2-month sprint. This is not a blip. We may be bending the curve this time, but they're already talking about an even worse situation in 6 months. This is going to be an issue until there is a vaccine. And what does that mean? Well, that means the Department of Corrections has to have a plan and has to articulate the scientific basis to assert that what they are doing is sufficient, because they haven't been able to do that. And in fact,
are any of those who are released or about to be released your 5 clients?
We believe each of our 5 clients is justified in being released.
My question is, does the plan or the released individuals so far include any of your 5 clients?
None of our clients are within the list of people that they have identified as being released.
You're talking about the commutation list, but I thought I saw in the briefing that Ms. Colvin was on a list to be transferred to a different setting.
They've issued a list of all the people that are in this round of releases, and her name does not appear on that list. I think what they are saying there is that they are considering to allow her to join a particular program, the Community Parenting Alternative Program, but they haven't made that determination yet. She has not been told that that's actually what's happening. So no, there's no commitment from the Department of Corrections with respect to any of our clients that they will be released.
Let me ask a follow-up question too. There's been some assertion that victims aren't getting sufficient or won't get sufficient notification. Tell me about the statutory requirements, the constitutional right, if any, that the victims have here, and how that should be addressed in your proposal.
Absolutely, Your Honor. If you look at our petition, we even outlined this issue that the state needs to grapple with. That victim notification and supporting survivors of crime is absolutely essential. And we readily admit that, and we agree with that. And this is a situation, though, where the state can walk and chew gum simultaneously. It's a false dichotomy to say that we can't release people and can't support people, the victims of crime. That's a false dichotomy. They can do both. In fact, they have the obligation to do both. What's interesting is if you look at the declaration, one of their declarations, one of the folks that provided it on their information, they identify about 7,800 people that are within 18 months of release. About 3,400 of them have no victim notification requirement as a part of their sentence. All of those people can be released without this issue even coming up as something to be concerned about. And again, sorry.
Counsel, I have a question. So your petition asks us to release individuals who are 50 years or older or have identified medical problems or comorbidities. Is that correct?
That's right, Your Honor.
And you think all of those individuals should be released?
No, Your Honor. We've never taken the position that every single person that falls within one of those categories should be released. What we have said.
And so, for instance, I'm looking at, rampage killer and serial murderers and serial rapists. And so are you suggesting that someone take discretionary steps with regard to each and every one of those individuals to make a determination and balance public safety against your request? Is that what you're asking, a discretionary review for each of these people?
No, Your Honor, I don't think that's necessary because I think it would be readily available to identify groups of people that can be released without a lot of concern. So for example, as I said, there are 3,400 people who don't have a victim notification requirement that are within 18 months of their release. I would submit that a lot of those people can be released without much examination at all. If you're talking about all the individuals that are highlighted a number of times in the briefing, of course, there are going to be situations where people shouldn't be released. But the state seems to make it sound like they don't release people, ever. But
Counsel,
in fact,
what if I agreed with you that those are probably the people that are in the best position to be released immediately? Isn't that just my opinion of how I would exercise my discretion if I were in the executive branch?
And Your Honor, that's absolutely right. We're simply saying there are groups of people that can be released. Now, who those people should be, again, may fall within the discretion of the executive branch. So what this court can say is, you need to release enough people to make it so that it is safe in our prisons, or as safe as possible, because of course it's never going to be entirely safe. But the state needs to do more than what they have done to this point.
So the county, what do we do to make the people safe that we're releasing? So we'll make it safe for the people who are left, but we have no way of knowing what's going to happen to the people that we release. What is it that you would want the state to do? Because they have some obligation, I assume, not to simply open the doors and say, okay, you're done, good luck. Because we know that most of these people at this point haven't got housing lined up. They don't have community support. They'll probably become homeless. Homeless people are much more at risk than the average person in the population. So what is it that you think will happen to these people who are released?
Well, Your Honor, I would point out that yes, that homelessness for people leaving prison is a significant issue. In fact, the data that I have seen on this is that somewhere between 10 and 20% of people who are leaving prison will be homeless within the first year of release. The data is difficult to discover, but that's basically what the data shows. And what that means is that 80 or at least a very significant proportion of people have a place to go, just like our clients, like Cheyenne Colvin. She could be released today and go home to Spokane to live with her husband so she could give birth in a hospital in Spokane with her family. Just like Chanel Duncan, another one of our clients. He's got a release plan. Terry Kill is eligible for work release. He could be released today to his wife in Gold Bar. There are many people who will not be homeless, and the state can take quick steps to figure out who those people would be. And that might be another appropriate consideration that they would use in determining this question. But in addition, as this court determined in McCleary, it's not enough. You cannot allow an unconstitutional condition to go on simply because there aren't resources to alleviate it. The state has to find the resources to live up to its constitutional obligations. And in this regard, I would submit more needs to be done, both on the release side and on the support side for survivors. It's not as though the Department of Corrections is alone in this fight. The amicus briefs from from a variety of different community and different organizations demonstrate there are community-based resources that can be brought to bear. In addition, you could bring to bear resources from the Department of Social and Health Services. Other government agencies could be rallied to solve this problem. And again, it's not just this immediate problem. We're talking about 18 months. And during that period of time, we're going to have ups and downs. There are going to be moments where things are going okay, and then there are going to be other crises that arise. And
Counsel, can I ask you what your position is on whether there's another separate, adequate, available remedy?
Absolutely, Your Honor. I don't believe, the issue there is whether it's plain, it's speedy, and it's adequate. And it has never been the case that you could, in theory, have somewhere else to go. Because under Article 4, Section 4, you as the Supreme Court have the original jurisdiction to issue a writ of habeas corpus or a writ of mandamus against a state officer. Article 4, Section 6 gives exactly the same power to the superior courts, meaning that the superior courts can always be an opportunity or a venue where something could be filed. If that were the case, you would never be able to exercise your original jurisdiction because a superior court could always be.
Oh, can I ask you this, Mr. Sterling? And rather than just looking at it as an exclusive, it's not an exclusive jurisdiction issue. This court has considered and rejected in the past requests for extraordinary writs that would essentially compel another branch of government to comply with the law and the Constitution. I mean, that kind of that's Walker versus Monroe. That's sort of a general writ. It exceeds our constitutional authority because it would just make the judicial branch a superpower over the other branches as to how to solve really difficult problems. So given all the discretion that you acknowledge in how best to do this, what is the mandatory non-discretionary duty that we would compel the governor and Secretary Sinclair to comply with?
Well, Your Honor, I would submit that the case law is pretty clear on this point in the constitutional context, that the courts in Bullock and other places have talked about if there is an absolute constitutional duty to comply with the Constitution, namely a branch of government is violating the Constitution, this court has issued a writ of mandamus in those instances. That's Bullock.
Just to say comply with the Constitution? I mean, we mentioned McCleary, so kids are not in school right now. Clearly there are needs to nonetheless comply with Article 9 obligations. Do we also issue a writ of mandamus telling the state to comply with Article 9 and the way it deals with schools and COVID-19? I mean, how would that be different?
Well, I think there is a significant distinction there, Your Honor. Basically, at this point, there is nothing the state can do to address the issue of children in schools, except perhaps, and again, they may come to you and say, if there was a school district that was refusing to comply with do anything related to distance learning, that might be a legitimate claim that somebody could raise. In this context, what we have is the state is violating its constitutional duty to protect our clients because there are too many people in our prisons. And again, there is nothing the Department of Corrections could have done about this. This is a once in a century event we are going through. And I would submit to the court that not in the entire history of humankind has there been this level of social dislocation. The entire globe has stopped. And because of that, there need to be extraordinary remedies. And if we were here, if we had come before this court last summer and said, well, there's a chance this virus will come and therefore you need to release people. Yes, that would be a situation where clearly we wouldn't be entitled to a relief. But the danger is clear. The danger is obvious. The governor has acknowledged it by starting to release people. The state acknowledges it. And the release demonstrates the state recognizes that the danger is greater in our prisons than it is in the community at large. And why is that? Well, that's because we can all quarantine, as we are all doing. We are all at home with our families, keeping ourselves safe, but people in prisons don't have that luxury. They don't get to decide who they spend their time, share a room with. They don't get to decide who they share a bathroom with.
Counsel,
Well,
as you,
excuse
That's
me,
the difference.
I would like to point out that there are businesses, Boeing, for example, who have resumed their operations. They have their workforce coming in masks. They have the cleaning processes that they put in place. They have certain distancing. So people are beginning to resume business again. Whether that's good or bad or right or wrong, I don't know. But it does tell us that there are other ways that companies, for example, are handling the need to get on with business. And certainly the prisons need to get on with the business of rehabilitation. Again, I'm not sure release is the only option. And asking us to order that as the option seems to me perhaps counter to what other businesses and establishments are doing in the community as we speak.
And Your Honor, I would point out that this is part of the issue that we're confronting in this case. It's an utterly unknown whether what Boeing is doing is sufficient to protect its workers. Utterly unknown. But what is clear is that the only way to mitigate the danger that COVID provides is to require social distancing. And as Your Honor knows, the evidence suggests that if we don't social distance, we're going to create another spike. And we may not be able to bend the curve that time. And so what the state needs to do is come up with a plan to ensure that that doesn't happen in our prisons. And if you remember, in Ohio, there's no testing happening in our prisons right now. They've got about 500 tests left for a population of 19,000 people. And Ohio, the Department of Corrections there decided to test to find out how many people in our prison have COVID. Many who were asymptomatic, no basis to test them under the CDC guidelines. And what did they find out? They find out that out of 2,600 people, 1,800 were positive for COVID.
you have half a minute left on this amount of time. Can you quickly summarize exactly what it is, if we ruled in your favor, you would want us to order? What timeline and what specifically you would want that order to say?
Your Honor, we believe that our petitioners should be released immediately. We have demonstrated the individual danger to them. They should be released today. We believe that there are other groups that could be ordered released today along the lines of what we talked about. And at the very least, the Department of Corrections needs to do an analysis in order to determine what is the appropriate population level to keep people safe. We'd also ask—
I'm sorry, a minute ago you said you weren't telling us to direct certain groups to be released. So I want to know exactly what you think our order should say if we granted relief to you.
If I were drafting the order, Your Honor, I would say you should order that anybody within 18 months of release who doesn't have a victim notification requirement should be released. I would ask that you would order that anybody with a petition or our petitioners be released. But I would also then say, and the Department of Corrections needs to do this analysis so that it's scientifically based. What is the appropriate population level in our prisons to ensure that people can socially distance as appropriate? And what is that level going to be over the 18 months we're talking about? Again, what happens today is one thing, but what happens over the next 18 months is also incredibly important. And that's why this court should maintain its jurisdiction and appoint a special master to help the court understand what will need to happen over the course of time to ensure that the state lives up to its constitutional obligations. I see that I'm out of time, and I'd like to reserve unless there are any further questions.
All right, thank you, Mr. Strader. I'll let you know when you come back for rebuttal how much time is remaining.
Appreciate it.
Turn now to Mr. Sampson, arguing on behalf of Governor Inslee and Secretary Sinclair. Mr. Sampson.
Thank you, Chief Justice, and may it please the court. I am John Sampson, Assistant Attorney General for the respondents, Governor Inslee and Secretary Sinclair. For months now, the respondents have exercised their discretionary authority to protect all Washingtonians, both those incarcerated and those in the community. They have made difficult decisions on how best to protect the incarcerated population, how best to protect public safety, how best to avoid future harm to victims, and how best to protect those individuals who are released when they go to the community.
Mr. Sampson, can I ask you exactly where we're at with that now? I understand that as to one of your clients, Governor Inslee, the proclamation that was issued suspended a lot of laws and gave him and the secretary a lot of discretion to do other things. What has the secretary done? Have those 1,100 people that you've identified actually been released, or is that an aspirational number?
No, Your Honor, it's not aspirational. They have, many of them have been released. They're in the process of being released. The governor's direction gave 7 days from the date of the order, or as soon as reasonably thereafter as can be accomplished. And it's my understanding that as of this coming weekend, the prison population will actually drop down below 16,000. My understanding is it currently rests just above 16,000, which is a reduction from the close to 18,000 that had, I believe it was 17,700 before this action started.
Is that enough?
Your Honor, it's the respondent's position that it is currently enough under the current situation, under the current circumstances, based on CDC guidelines, based on the chief medical officer's evaluation, based on the infectious disease physician's evaluation. That reduction should be enough when coupled with the reduction of violator population. The department, before this action started, made a discretionary decision not to arrest low-level violations, not to arrest for those.
So those have certainly made a difference, but we've all seen the ombuds report and the photographs there. How does what you're saying square with the pictures of people one on top of another at Monroe?
Your Honor, those photographs, first of all, they were taken almost 2 weeks ago, before any reductions had started from the releases that the governor ordered. Second of all, I was told by the superintendent of Monroe Complex that the minimum security unit this coming weekend will be able to guarantee a 6-foot social distancing, if that's assuming the inmates comply with that. And as far as the characterization of the inmates being on top of each other, one of the photographs showed 4 inmates standing together in the hallway doorway. That was their choice to gather together. There was room that they could move apart from. So they're even when the department provides the space, it's still going to be up to the individuals in the institution to exercise social distancing the same way that we have to. When we go to the grocery store and there's more than 2 people in an aisle, you have to engage in some of your own responsibility of social distancing. And
will the steps that the department takes change if we deny the petition?
Your Honor, if the court denies the petition, the governor and the secretary are still going to take steps to protect the incarcerated population. If it becomes necessary to release more individuals, they will do that. If they determined, I believe the secretary talked about bringing in temporary shelters. The department has already started in the camps. They've already relocated areas to ensure that there's 6-foot separation of all sleeping areas in the camps, and they're looking to do that as well in the prisons as much as physically possible. As I said, the minimum security unit, they will have that 6-foot separation this coming weekend if they don't have it before then. I would also point out, to correct one of the points regarding Petitioner Colvin, the department has put her on a fast track along with several other, there are approximately 26 women who are currently pregnant at WCCW. The department has looked at all of those individuals for fast tracking to the community parenting alternative. There are 6 that are under a federal sentence, so they cannot be released, and 5 that have sentence structures that prohibit transfer, but approximately 15, including Petitioner Colvin, is expected to be released within the coming week or so. If not this week, next week, and hopefully no time after that.
Mr. Sampson, I have a question about something you just said when you were making reference to the potential for inmates to be sleeping in a manner that comports with social distancing. You use the language something like "as is practicable," and you made reference specifically to the minimum security facilities. What does it mean to say "as much as practicable"? Because that seems to me to be an option for a significant loophole for the Department of Corrections to simply say, well, we can't do it. So I need more specificity from you about what is reasonable that you believe the Department of Corrections can commit to related to where people are living, sleeping, et cetera.
Your Honor. Yes, Your Honor. I cannot guarantee, and I don't think the department can guarantee, that every single prison cell is going to provide 6 feet of sleeping distance. But what I can say first is that's not constitutionally required. As the U.S. District Court in the Plata case, which they rely heavily upon, the U.S. District Judge just ruled in a similar type of action regarding COVID-19. 6-foot distancing is not constitutionally required, and it doesn't show deliberate indifference. It's just one of the many recommendations. So the department will as much as possible, strive to guarantee 6-foot distancing for all prisoners. There may be some, especially in some of the older institutions, where it's just not physically possible because of the structure of the building to always guarantee 6-foot distancing, but they will strive to do that regardless of how this court rules in this case. And
well, I have a follow-up to that then.
Yes,
what's your view of the court appointing a special master to oversee those kinds of issues and report back to the court with respect to how that's working?
I have a couple of points for that, Your Honor. First, if this is treated as a mandamus action in which it was filed, the role of the special master is limited to developing facts to show a clear existing duty, whether that's being performed or not performed. And because petitioners can't show, other than a broad allegation of a constitutional duty to protect, they can't show a specific duty, then the role of the special master really doesn't fit mandamus. The second point on that is if the court treats it as a personal restraint petition, the RAPs specifically require that if the court wants factual development, the proper remedy is to remand to a superior court for reference hearing. What the department would propose, if this court does not feel sufficient facts are presented, is do what the court did already, which is to require the department to submit another report within 2 weeks of how the situation currently exists. And I would point out, Your Honors, that the fact that there would need to be further factual development and the fact that the petitioners can only show a broad constitutional obligation shows this is not proper for mandamus. As this court said decades ago in a mandamus action against the department when the department was DSHS, mandamus contemplates the necessity of indicating the precise thing to be done. It is not adapted to cases calling for continuous action varying according to circumstances. So we all know that.
But doesn't it show that this case is totally appropriate for a personal restraint petition, that is a petition in the nature of habeas, where there is a vehicle for fact-finding, and there's also a vehicle for release in extraordinary circumstances, pending fact-finding and resolution?
2 points on that, Your Honor. First is, if it is treated as a habeas, it can only be for the 5 named petitioners. They do not have standing to bring an action on behalf of all the prisoners. In fact, this court, in the case that they rely on for the proposition of a class action habeas, which I believe was I believe it's Thomas is what they cite to. The court actually said that there's a difficulty in having a class action habeas because habeas looks at the particular circumstances of each individual. And so what the proper remedy would be is to have a declaratory judgment action. Furthermore, if this court did treat it as a PRP as to the 5 named petitioners, before this court can appoint us a special master to oversee the department's progress, the court would first have to find that there actually is a constitutional violation. And that brings us to the standards that Your Honor asked about for a cruel punishment claim. They have not made a gun law analysis. They have not argued specifically.
Counsel, before you go ahead into that standard, let me just ask for you to clarify a point that you had made, that the department would find it acceptable for you to come back with another report advising the court within perhaps the mandamus framework of what other steps you're taking to protect these individuals as well as the population. Is that correct? Is that what I heard you say?
Well, Your Honor, our first position is that the court should deny the petition outright because there is no clear existing mandatory duty. And the fact that they would need additional facts developing or show how the department is responding to a change in circumstances shows it's not a proper mandamus. But if the court is concerned, one alternative would be to do what the court has done and ask for a second report. But the department's position, or the respondent's position, the governor and the secretary's position is that we don't need to get that far, because to get that far, the petitioner has to prove that respondents are not performing a specific clear existing duty, and they have not done that. Or if it's treated as a PRP, to obtain the type of oversight they're asking for, they would have to first prove a constitutional violation, and they have not done that. But if
Follow up on that. This is, of course, a very difficult situation, and if the wrong decisions are made, it can be a lethal failure to act or failure to protect the prisoners. If you did provide a report in 2 weeks, what do you think, in addition to the report you've currently submitted, it would include? Would it show that there was testing so you actually know who has it and how it's being spread? Or would that not be part of what you would report?
Your Honor, it would include that. And I would point out on the issue of testing that the department has currently tested over 300 prisoners. The numbers that have been found to have a positive test is just 12 in the prison and the one outside the prison. That is a ratio comparable, as far as testing numbers, is comparable to statewide. Statewide, there's been 147,000. And if you compare that to the population of over 7 million, that's roughly 2%. The department is resting at about 1.8% of testing of DOC population. So certainly, and again, that is not our position that the court should order a report. Our position is that the court should deny the petition because they legally fail as a matter of law. But if the court did order a report, that would certainly be one factor that we would submit. We would also submit if there were additional releases ordered by the governor or by the secretary, or if there was a further reduction in population based on their discretion, that information would also be included.
Mr. Sampson, could you return to the discussing if the court were to regard this as a personal restraint petition, at least as to the 5 named petitioners, whether they've made the showing to entitle those petitioners to individual relief?
Yes, Your Honor. So starting with Mr. Rohn, he was sentenced to life without parole. His sentence contemplates that he will spend the remainder of his life, no matter when that ends, in prison. There is no statute that allows him to be released, and there is no constitutional violation that would allow him to be released. If this court has said repeatedly in the Toure case and in the Campbell case, which involved unconstitutional conditions at this special commitment center, if there are unconstitutional conditions, the remedy is not release from confinement. The remedy is to fix those unconstitutional conditions. And we would submit that they have not even made that first step of showing unconstitutional conditions. Under the cruel punishment clause, there are 2 steps. One is to show a substantial risk of serious harm, and we agree future harm can meet that standard, but it still has to be a substantial risk and it has to be serious harm. And second, and more importantly, is they have to show deliberate indifference. And in this case, just 2 days ago, petitioner's own expert, Dr. Griffinger, submitted a supplemental declaration where he said, other than releasing people over 50 and vulnerable inmates, the department's protocol for responding to COVID-19 is as good as he has seen in the nation for responding in a correctional facility. if their own expert admits that the department is doing the best that he has seen, then they cannot meet the second prong of a cruel punishment. So they, cruel punishment claim. So they cannot prove a constitutional violation. They cannot obtain relief. I would point out Mr. Berry, although he has a release date of 2029, he is been accepted by the Clemency Board for a hearing in June, which is their next scheduled hearing. So they are going to give his request for clemency serious consideration at that time. And I understand that Mr. Duncan has a release date in December. At the very end of December, it's actually January 7th, but the department can release somebody 10 days early. And so if you do 10 days early, he's scheduled to be released in December. Certainly if circumstances change, the governor may include Mr. Duncan in one of the early releases, but right now he does not fall within that, given his sentence structure and the fact that his release date is not until the end of December.
Counsel, can you explain to me what you mean by circumstances change? If you're not testing people, what are the changed circumstances that you foresee would create a change in the reaction from the respondents?
Well, Your Honor, the department is testing people. They have conducted over 300 tests. They conduct the tests in accordance with Department of Health guidelines and CDC guidelines. So if somebody is either have a fever over 100, or if they answer yes to any of the screening questions, such as have you had contact with somebody who's symptomatic to COVID, they will be screened, they will be tested. That testing ratio is comparable to what's available now for the people in the community. In the community, it's about 2%. In DOC facilities, it's a little under 2%. The department ordered additional test kits before this all began. When they first learned of the dangers of COVID-19, they ordered 100 additional test kits for 4 prisons and 50 additional test kits for all the other prisons. They currently have over 500. They do not want to hoard the tests that might be used by members in the community, so they don't want to order too many, but they're also ordering enough to conduct tests in accordance with the Department of Health guidelines. So
what are the changed circumstances?
Well, for instance, I'm saying that if there were a change of circumstances, for instance, if there was a positive test in another institution, and so far the only institution that has had a positive test is the Minimum Security Unit in Monroe. If there was a positive test of incarcerated population in another prison, that might be a change in circumstance that the governor and the secretary would look at to engage in either isolation or possible releases. Those are the circumstances, though, that require the exercise of discretion. And as this court recognized, the petitioners rely heavily on the Cougar business case to say that they have the right to seek this mandamus relief. But in that Cougar case, this court actually recognized the executive branch is the branch that's best suited to respond to emergencies, because things can change very quickly, circumstances can change very quickly, and the executive branch is best suited to respond to those changes in circumstances.
Counsel, isn't our understanding about the development of and the transmission of COVID-19 a change in circumstances, given that we're now understanding that asymptomatic carriers are spreading this in a manner that seems to be pretty widespread? So I don't understand how just addressing those who are showing symptoms resolves that question.
Well, Your Honor, if the department could test every single inmate, they would, but as petitioners' own experts, Dr. Shansky and Dr. Sysis admit, and this is at page 176 of their record, it is the lack of testing supplies makes this impractical and not possible at this time. So
exactly. So that my question then is that if we know that asymptomatic transmission is occurring in the community, and we know that we don't have enough testing to identify those asymptomatic carriers, how can we conclude that what the Department of Corrections is doing is reducing that spread if they're not able to ensure that there is social distancing throughout the system?
Again, Your Honor, social distancing is just one recommendation of the CDC. And the department is trying as best as its ability to do that. The other thing is they have supplied mask face coverings and made it mandatory that both the incarcerated population and staff wear those. They also, depending on the circumstances, require additional PPE to be worn, either by incarcerated individuals or staff. The department isolates individuals who are suspected as well as confirmed. So right now there are 97 individuals in isolation, and with only 12 confirmed tests, but they still have an additional 85 they put in isolation. And then they quarantine individuals. They do contact mapping, figure out who that individual came in contact with, and put those individuals in quarantine. That is CDC recommendation. That's what would happen if that occurs in the community. You would be put in isolation if you're suspected or confirmed, and you'd be put in quarantine if you're come in contact with somebody. That's the same thing that's occurring in the community. What the department has to look at in deciding whether or not to release additional people to the community is those risks, but also other risks, including the harm that can come to victims. As the court is aware, there's been some submissions to this court, among others, a woman whose husband threatened to kill her and has in fact attempted to kill her, solicited, he's in for solicitation to commit murder. She is deathly afraid that if he is released, and he falls within the category of both over 50 and he has vulnerable health conditions, he will kill her. There's countless other victims who have equal concerns. The department has to consider those concerns and respect those, and they attempt through the approved plan process to protect against violations occurring again. There's also a serious concern for the individuals who are released to the community. As council recognized, a large majority of individuals under normal circumstances become homeless. The department has limited resources. They do provide housing vouchers. They attempt to find housing, but it's not always possible. And if we release several thousand, right now we've released 1,000 extra compared to the regular, and that's in addition to the regular 700 or so a month that are released. If you continue adding 1,000 and 1,000 and 1,000 to that, the resources are going to be broken and the system's going to be broken. As the county amicus brief pointed out, the harm that will be suffered by the cities and the counties, by the local hospitals that are going to have to provide treatment because these individuals don't have medical insurance. That's going to be.
Mr. Sampson, could I jump in and ask you about that? Because it occurred to me, obviously, DOC has a responsibility to everyone who's incarcerated, but don't they also have a responsibility to everyone who's on supervised release?
Yes, Your Honor. And they have two responsibilities. They have a responsibility to protect that individual to the extent that they are the ones who put them in that situation. And then they have the responsibility to protect people that may be harmed by that individual. So there's actually a double responsibility in that situation. And as the amicus brief by the Sexual Violence Law Center and Legal Voice pointed out, there's a serious concern, even when you're talking about quote unquote nonviolent offenders. The fact that they are currently serving a nonviolent offense doesn't necessarily mean that they're not a danger. They may have pled down from a violent offense or from a sex offense to a non-sex offense, nonviolent offense. So there are legitimate concerns to the community at large, and there are legitimate concerns to the people that are released. And the department does have an obligation to the extent they have resources to provide those to the people who are being released. But the statute limits the department's ability to assist people when they are released under supervision. And they're limited to what's commonly called gate money, which the statute says is $40, but the secretary can raise that somewhat each year. Then they're allowed 6 months of housing voucher at an approved housing location. And then they're allowed a little bit limited more money. And the department has taken the discretionary position to give the people that are currently releasing under the governor's order, they're giving them a prepaid Visa card, and they're giving them, they're helping them work in an expedited process with DSHS to get benefits with the hope that they will get an electronic banking card delivered to wherever they're going within a few days after the release. But again, the resources that we have are already being stretched. If the court were to the order to the release 1,000 more offenders, the fear is that it would break the system.
Can you address, I mean, we all know, and in fact, many are concerned about an increase in certain crimes, domestic violence and others during this difficult period. What is the department in particular doing as new people are brought into DOC custody?
As they're brought into DOC custody for their...
Right, I mean, you talked about contact mapping and isolation, but my understanding is that the population in each of the facilities is not a static population.
That's correct, Your Honor. So when someone comes in for instance, a domestic violence, the department tries to provide programming to help them deal with anger management and other issues that may have caused that. Then that's while they're in prison. And if you release people early, you may actually be cutting off some of that programming that they would be receiving.
Yeah, and actually, I guess I should be more specific, Mr. Sampson. I'm really thinking in terms of any screening and COVID-19 protections as new individuals are brought in.
Oh, yes, Your Honor. I'm sorry. What the department, they currently screen all incoming inmates as well as staff. And what they do is they have a two-step process. One is they do a temperature reading of all staff, and then they ask the staff certain questions, and they have excluded from work over 1,000 staff members. And they only come back to work if there is screening approval is done by medical professionals. And then as far as inmates, when they come in from a new intake, they are screened as well. And they can have their temperature reading done, and they will also be asked the same screening questions. If they are either have a high temperature over 100.4, or if they answer yes to any of the screening questions, then they're seen by medical staff for an evaluation of whether or not they should be quarantined or isolated. And the department, in accordance with CDC guidelines, has now begun 14-day quarantines of all new intakes. So that was one of the last recommendations. There were two recommendations that the department just recently adopted. One was the quarantine of all new intakes, and the other was providing alcohol-based hand sanitizer to the inmates, and that is as well as staff. And staff had that for several weeks, but now the department is actually providing the alcohol-based hand sanitizer to the inmates. So
is that true for the women's prison as well as for the reception to the men's prison?
Your Honor, it's my understanding that that applies to all the prisons. There was one instance the day after it was handed out where an inmate ingested the alcohol-based sanitizer and had to receive medical care. So I think that what the department's response to that is they're going to make it so that it has to be a supervised use of the alcohol-based hand sanitizer. But it's my understanding it's being provided for both. In addition, they have they previously.
Go ahead and finish your sentence, and I have a question.
I was just going to say they continue to hand out free soap, and they have hand washing facilities for all inmates.
So, Counsel, in your report on the steps that the department is taking, you filed one on April 13th and then one on the 17th. And you just made reference to it that you're now handing out masks to everybody to wear. Does the court have the right to ask any questions about that protocol? And that the fact is, in the record, there's some indication that while inmates may be given a mask, they're asked to wear it for a week, that there's no washing of the mask. Does the court have a right to ask about how you are implementing what you have outlined as your plan to somehow address this question of this COVID-19 in prison?
Well, Your Honor, that raises, is there an issue of fact that needs to be resolved and whether or not that's material? And so if the inmates are saying we only get one mask and the department is saying you actually get two masks and they are washed, if that would be an issue of fact that could have to be resolved, but is it material to the outcome of the case? And in mandamus, it's not, because they have to show a clear existing duty. And again, it's not a duty to generally comply with the Constitution. It's not a duty that changes based on the circumstances. It has to be a clear and specific one, which they have not proven.
Would that be a material dispute if it were construed as a PRP, or if the motion to amend to consider as a PRP were granted?
No, Your Honor, because again, they fail to show deliberate indifference. So their constitutional cruel punishment claim would fail, even if there is a dispute as to how many masks they get, whether they're cleaned. They haven't proven deliberate indifference, and so their claim must fail.
So Mr. Sampson's time has expired, but I don't want to cut off any question from any other justice. Are there any further questions for counsel? Okay, thank you, Mr. Sampson.
Thank you, Your Honors.
Thank you. We're back to you, Mr. Straley, and let me see, you have just under 7 minutes for rebuttal. Please proceed.
You're on mute.
Oh, okay, there. Thank you, Your Honor. I have 3 points to make. First, let's talk about this testing issue. Yesterday, there were 1,075 people in quarantine and 97 people in isolation. That's up from 90 the day before, which means they don't have enough tests to even test half of the people they are worried have COVID, let alone all of the other people who are maybe asymptomatic. We heard yesterday in Eastern Washington, a grower decided to test his employees, not because they were showing COVID, but because he was concerned. And what did he find out? Out of a group of 70 people, 36 had COVID. There is no way the Department of Corrections has any idea actually how prevalent COVID is inside. And that's crucial. The other point is they say they set up this 14-day quarantine when people come in. If you read the briefing very carefully, that may be the case at the men's prison in Shelton, but they don't say anything about quarantining women who are coming into the women's facility. It's silent on that. And in fact, the women's facility is well known to be overcrowded. That's why they have people at Yakima. In fact, they haven't demonstrated they are actually quarantining any women that come in off the street. Third, it's interesting that the only evidence that he's discussing is from our experts. The only evidence from a medical expert or a scientist comes from the petitioners. The defendants, the respondents haven't presented you with anything scientifically valid to support what they are talking about. That's important. 2, remedies. Mandamus and PRP or habeas corpus are equitable remedies. They can be used to fit a particular circumstance. So if it requires a mandamus that a monitor to be appointed, you have that authority under the Constitution. And remember, you all can waive any particular rule of appellate procedure that may be limiting you. We don't.
Can I ask you about that, Mr. Straley? Because I mean, the mandamus, both the habeas authority and the writ of mandamus authority come out of Article 4, Section 4, insofar as this court. And I'm still concerned that there's not a precise thing that you would have us mandate. It would be, exercise your full authority, comply with the Constitution. It seems a very general obligation that they have plenty of discretion to figure out how to exercise. And that just doesn't seem like so it's not a procedural rule I'm concerned about. It's that constitutional prerogative of when the judiciary gets to interfere with the exercise of discretion by another branch, especially in an emergency.
And absolutely right, Your Honor, that is a concern. But here we have demonstrated a very precise duty. The duty is to protect our clients from COVID-19. And all of the scientific evidence before the court indicates there have to be releases in order to do that. In fact, the state is agreeing with us because they're ordering releases. If they truly believed it was safe, they wouldn't order anybody released. In fact,
but aren't they just, I guess I'm still concerned because what is the mandate? We're going to tell them release X number, apparently, but I heard you say earlier they'll have discretion on who is safe to release. So are we going to, there's something in the briefing about not letting people transfer from jail into DOC. Is that part of the mandate?
That might be, Your Honor, that might be an appropriate thing to do, yes, under the circumstances, to keep people from coming in and separate.
Well, it might be a smart thing to do, but is it constitutionally compelled?
What is constitutionally compelled is to operate a safe prison system. And in this context, what that means is there is a number of people that can be safely held in our prisons. And that is a number that can be determined. Can I tell you today what that number is? No, but neither can the Department of Corrections. What we do know from the experts is that it is fewer people than are currently in prison, and it's fewer people than would be released under the current plan. And we also know—
I'm asking for a certain level of specificity in your ask. So the fallback position from respondent is, have us do another report in 2 weeks.
Mm-hmm.
If we took that approach, what would you have us tell them must be in that report?
So I would say that our petitioners should be released because we've demonstrated they individually are at risk. And then DOC has to have done an analysis of its prisons to determine what is an appropriate level of social distancing. And it has to be scientifically valid. It has to provide you with some evidence to show why was this category of person chosen? How would that impact the prison system at each prison? For example, at Larch, they're sleeping on top of each other there. They are crowded there. How is this going to solve Larch's issue? How is it going to solve the problem at Stafford Creek? What has to happen, it has to be a report that is indicative, that demonstrates a connection between what they are doing and what is actually necessary. And so what we would suggest, and that's the other reason a special master is important, so that you can get unbiased, unvarnished evidence to help you make the determination what is the appropriate level to meet the Constitution.
Well, can I ask you again about the special master? Because why would that person or a member of this court or the entire court be in any better position to determine what's best practice?
I would say that they would be, because they would have evidence that isn't currently before the court on the precise question. But what is before the court is that they are currently operating an unconstitutional system. And that's the most important thing, because as this court determined in McCleary, you have an obligation to step in to rectify an unconstitutional circumstance. And that is the undisputed evidence in the record, okay?
But do you agree that in McCleary, the court emphasized that what constitutes a basic education and how best to provide it is entirely within the legislature's prerogative? So why is it not entirely within the executive's prerogative to determine how best to address COVID-19 outbreak in prisons?
Because there's no dispute that the fact that releases are essential. Because if people are not released, they are operating an unconstitutional circumstance. They have alleged that they have now released people, and they have alleged that that's sufficient. They haven't proven that, and it's their burden to prove that, because they are operating an unconstitutional prison system, and all of the evidence is to the contrary, Your Honors. All of the independent evidence is to the contrary. That's the point. There is no real material issue of fact here. The evidence before the court documents that this is an unconstitutional circumstance.
We have a question about whether social distancing actually works.
Well, Your Honor, I believe that social distancing is the only tool that has truly been identified to keep as many people safe as possible. That's why we are all in quarantine, as I understand.
No, we're not all in quarantine. I live with my family. We're not all in quarantine. We live sole. I mean, I don't know of anyone who is living completely alone. Maybe there are people, but I don't know who they are. We all interact at various points. And we know that even 6 foot distancing, there are COVID particles in the air. So I guess what I'm asking you is if it were a sure thing and we're not doing it, then you might be in a different position. I just wonder, where is the evidence that it is a sure thing, that if we social distance, we are ensured of protecting each other, or in your case, your clients?
Your Honor, I agree it's not a sure thing, but that's the issue with this disease. And what we're doing is operating on best available information. And the best available information from the CDC and every scientific organization is that social distancing is truly the only thing that can be done to prevent people from getting this illness. And while it's true that people are meeting together, the difference between what we can all do out here and what people in prison can do is astronomical. They don't have the ability to keep themselves safe. They are reliant on the state to provide them the opportunity to be safe. We can all hold out in our homes. We can decide who we allow into our homes. People in prison do not have that option. And that's why this court should step in and order the relief that we've requested. I see that my time is up, but I'm happy to answer any other questions the court may have.
Thank you, Mr. Straley. Do any members of the court have any further questions? All right, I want to thank both counsel for your arguments, and thank you for being our first counsel to present oral argument via Zoom. That concludes the oral argument in this case, and the court is adjourned.
Thank you, Your Honor.
Okay.